Okay. Good evening. Welcome to the 31st Annual Silha Lecture. My name is Jane Kirtley, and I'm the director of the Silha Center for the Study of Media Ethics and Law, which is based at the University of Minnesota's School of Journalism and Mass Communication. We are so happy that you are able to join us tonight. This year's lecture topic could not be more timely. From culturally offensive Halloween costumes, to protests over controversial speakers or signs, to trigger warnings in classrooms, debate over freedom of expression only seems new to America's college campuses. These and similar issues have roiled higher education for decades. Randall L. Kennedy, the Michael R. Klein Professor of Law at Harvard Law School, will revisit key disputes that are likely to continue to challenge First Amendment principles when he presents the Silha Lecture, The Politics and Law of the Culture Wars in American Higher Education, 1950 to 2020. And let me just add that that's not a typographical error. That really is what he's going to talk about. But more about Randy in a moment. First, we want to take a few minutes to say thank you. The Silha Center was established in 1984 with a generous endowment from the late Otto Silha, who was former president and publisher of the Minneapolis Star and the Minneapolis Tribune, and his wife, Helen. Helen is with us tonight, along with her children, Stephen Silha and Alice Ryman. Helen, we are so grateful for Otto's vision and your continued support during the past 32 years. Thank you. I would also like to thank another individual for his ongoing support of the Silha Center. As many of you know, Professor Al Timms has directed the School of Journalism and Mass Communication since 1997. He's stepping down from that position at the end of this year. Al will be much missed by all of us at the School of Journalism and Mass Communication, but I would particularly like to acknowledge how much his support has meant to me personally and to the Silha Center over the years. Thank you, Al. Since 1984, the Silha Center has been the vanguard of the School of Journalism and Mass Communication's scholarly efforts and public outreach in the areas of media law and media ethics, and has achieved international recognition for its work. The Silha Center's thrice yearly newsletter, the Silha Bulletin, I wish we could do it 3 times a week, covers emerging issues in media law and ethics, and is researched and written by Silha research assistants. Copies of the bulletin are available outside the auditorium, and I hope you'll pick one up on your way out. Silha funding has supported the work of dozens of graduate and law student Silha fellows and research assistants throughout the years, many of whom can now be found teaching and conducting research at leading universities and practicing at law firms across the country and around the world. Our 3 current Silha RAs have all been instrumental in ensuring the success of tonight's lecture, and I would like to thank all 3 of them for their efforts: Casey Carmody, Scott Memel, and Ronald Wachowski. Every year, the Silha Center offers programs that draw the public into an ongoing discussion about ethical and legal issues facing the media. Tonight's lecture is the 31st in the series that has become the Silha Center's signature event and provides a platform for distinguished and innovative thinkers from journalism, ethics, and law to share their insights and expertise. Tonight's lecture follows in that tradition. In an op-ed essay, Black Tape at Harvard Law, which appeared in the New York Times on November 27, 2015, Professor Randall Kennedy responded to activists who had argued that when vandals defaced photographs of African American law school professors by placing black tape over their faces, it constituted a racial hate crime. He wrote that although the taping was disturbing to many, the motives of those who placed the tape over the photos was not clear. While acknowledging that the action might have been racist, he argued that there is a need to calibrate carefully its significance. Noting that incidents like the one at Harvard Law inspired difficult but earnest and probing conversations, he suggested that in the long run, reformers harm themselves by nurturing an inflated sense of victimization. The author of numerous books and articles, Professor Kennedy is uniquely qualified to discuss race relations in the United States. His books include For Discrimination, Race, Affirmative Action in the Law, The Persistence of the Color Line, Racial Politics in the Obama Presidency, Sellout, The Politics of Racial Betrayal, and many more. In 1998, he was awarded the Robert F. Kennedy Book Award for Race, Crime, and Law. Professor Kennedy attended Princeton University, Oxford University, and Yale Law School. He clerked for the distinguished Judge Skelly Wright of the United States Court of Appeal in the District of Columbia, and with United States Supreme Court Justice Thurgood Marshall. He's also a member of the American Law Institute, the American Academy of Arts and Sciences, and the American Philosophical Society. He currently teaches courses on civil rights and civil liberties, constitutional law, and race and law at Harvard. And now, please join me in welcoming Professor Randall Kennedy.
Thank you very much for the gracious introduction. It's a great honor for me to be here. I've had a wonderful day here. I'm very grateful for the hospitality that I've been shown. Our subject this evening is the politics and law of the culture wars in American higher education, 1950 to 2020. It's a big subject. To illuminate parts of it, I'm going to follow and comment upon a line that leads to controversy wherever it is found in American life, which is everywhere in American life, namely the race line. I begin with events in February 1960. In February 1960, 29 black students at Alabama State College sat in at a racially segregated grill located in the county courthouse in Montgomery, Alabama. They demanded service. Service was refused. The grill was closed, and the black students were told to leave. They initially refused to leave, but then the police were called, and they were once again ordered to leave, and this time they did, though they remained outside in the corridor for about an hour. The sit-in occasioned neither arrests nor violence. Still, the governor of the state of Alabama heard about the sit-in, and he called the president of Alabama State College and, quote, advised the president to investigate the incident and to consider expelling the students involved. That's the way the court portrayed it. Actually, that's not really the way it happened. The governor of the state called up the president of the college and said, I want you to immediately expel these students, and if you don't, I'm going to close down the college. The president of the college expelled the students, just wrote them a letter saying, you are hereby expelled. And he said in the letter that they were being punished, quote, for conduct unbecoming a student or future teacher in Alabama. You're being punished for insubordination and insurrection and for inciting other pupils to like conduct. Well, a few of these students decided to consult an attorney, and 6 of them challenged the legality of the expulsion. Their attorneys argued that the action taken by school authorities violated the federal Constitution. They mainly focused on the absence of any notice or any hearing or actually even the filing of any formal charges. The case that stemmed from their challenge is Dixon versus Alabama State Board of Education. The federal judge who presided over the case ruled in favor of the state defendants, despite the absence of any formal charges being filed and despite the absence of any hearing prior expulsion. The judge concluded that as federal constitutional law then stood, the students were entitled neither to notice nor to a hearing. Now, it bears noting who the judge was who was presiding over this case. The judge who was presiding over this case was a very fine judge, and indeed was one of the heroes of the Second Reconstruction, the Civil Rights Revolution. Frank Johnson, very distinguished judge, presided over this case and said to the students, basically, I'm sorry to have to rule this way, but you have no case. That was the state of the law at that moment. At that moment, students had no rights that school authorities at public universities were bound to respect. Students were completely vulnerable in 1960. At many public universities, authorities would just categorically exclude certain speakers from coming to campus. If a speaker was a socialist, if a speaker was an anarchist, if a speaker was a communist, nope, can't come. There in the southern United States, of course, if a speaker was against segregation, nope, can't come. Let me read you a college regulation from the handbook that governed student conduct where my mother went to school, South Carolina State College, 1960. Quote, the student body or any part of the student body is not to celebrate, parade, or demonstrate on the campus at any time without the approval of the office of the president. That sort of provision was, by the way, not, that wasn't atypical. That wasn't viewed as being really out of the ordinary. Students had no federal constitutional rights. And the reason why students in the position of the students I mentioned in Alabama, the reason why they were so vulnerable had to do with two doctrines in particular. One was the right-privilege distinction. The idea was, well, you don't have a right to a college education. It's a privilege. And so anything that happens to you, if you don't have a right to the education at all, anything else that happens to you is not the deprivation of a right, because after all, you don't have a right to be at the public university anyway. And the second doctrine was in loco parentis. The idea was that the school authorities were in the shoes of the parents. Anything that a parent could do, the school authorities could do. Now, after the students in Alabama, after they lost their case at trial, and despite the unpromising prospects, they appealed. They appealed to the Fifth Circuit Court of Appeals. And then something remarkable happened. They prevailed. The Fifth Circuit said, these students, they are persons in America. And it just stands to reason that anybody in America should at least have the right to a hearing. I mean, the right to a hearing. I mean, maybe somebody made a mistake. Maybe an eyewitness just pointed to the wrong person, or maybe the person who received this letter, maybe there was a clerical error. I mean, mistakes do happen. Aren't you at least entitled to a hearing? And so the Fifth Circuit Court of Appeals reversed Judge Frank Johnson's order and said that at least the students were entitled to a hearing. This case, Dixon versus Alabama State College, is the case that opens up the door to a recognition of federal constitutional rights on behalf of students. That's the case that opens the door. Few years later, there was another case, again, Deep South. At Booker T. Washington High School in Philadelphia, Mississippi, a group of high school students went to school wearing on their clothes a small button that bore two insignia. One was a slogan, "One man, one vote." The other insignia was bearing an acronym, SNCC, Student Nonviolent Coordinating Committee. The principal of the school said to the students wearing the buttons, "Remove the buttons." Those who did not remove the buttons were sent home. So a bunch of students were just sent home. The next day, many of the students who were sent home did not wear their buttons, but there were a few who came back with the buttons. They were dismissed. They were suspended. 3 of the suspended students challenged the constitutionality of the principal's action. They argued that his action encroached upon constitutionally protected freedom of speech. The principal, on the other hand, argued that his prohibition should be deemed permissible under the circumstances because his prohibition assisted in the maintenance of proper discipline at the school. Allowing the students to wear such buttons, he argued, would result inevitably in distraction and commotion, undercutting the school's central mission, education. The school authorities won the first round. The plaintiffs, however, appealed, and again the Fifth Circuit reversed. The Fifth Circuit, in a case Burnside versus Byers, came to the conclusion that these students, albeit high school students, did have First Amendment rights, and the Fifth Circuit said, well, they didn't disrupt anything. They weren't, there's no evidence in the record of disruption. There's no evidence in the record of anything except them expressing a point of view. And under these circumstances, Fifth Circuit said, we think that the students' rights were encroached upon. Burnside versus Byers. Now, 3 years later, there was a case that went to the Supreme Court of the United States, and it's the case, actually, that when you take constitutional law, you read in this area. The name of the case, Tinker versus Des Moines Independent School District. What happened in Tinker was a group of students who were against the Vietnam War wore black armbands, and they were told to leave. They were dismissed. And that was challenged, and the Supreme Court of the United States upheld the students, saying that it was a violation of their federal constitutional rights insofar as they weren't disrupting anything. It was a violation of their federal constitutional rights for the school authorities to just tell them, no, you can't wear those anti-war emblems. And in Tinker versus Des Moines Independent School District, Justice Abe Fortas made a statement that subsequently become very famous in American constitutional law. His statement was that neither students nor teachers shed their constitutional rights at the schoolhouse door. In his opinion, Fortas cited repeatedly Dixon, the Alabama case, and Burnside, the Mississippi case, constantly was citing these cases. He built upon those cases. And the reason why I'm beginning my remarks sort of focusing on those cases is because I want people to remember that struggles for racial justice have repeatedly created the seedbed for rulings that expanded the rights of Americans to engage in protest, to express their beliefs, to use their freedom of expression. This has come up over and over and over again. Through its resistance to suppression, the fight for black liberation has helped to create a panoply of newly recognized rights with respect to freedom of expression. Let me give you some examples. To protect itself and its members from the hostile gaze of antagonistic white supremacist state authorities, the NAACP, the National Association for the Advancement of Colored People, moved the Supreme Court to acknowledge and defend freedom of association and organizational privacy. If you think about privacy, if you think about freedom of association in terms of federal constitutional law, what are the cases that you look to? You look to NAACP versus Alabama. You look to Shelton versus Tucker. You look to City of Little Rock versus Bates. All of these, late 50s, early 60s, what was the fight in the background? The fight was over segregation. These were state authorities trying to crush the NAACP, and in its efforts to protect itself, the NAACP drew up the First Amendment. They did more than just draw up the First Amendment. They actually, through creative lawyering, added new ideas to the First Amendment. Again, the whole idea, freedom of association, freedom of organizational privacy, those ideas, which all of us now intuitively rely upon, came from struggles for racial justice. To shield civil rights attorneys from rules that would have crippled their ability to further the aims of their clients, champions of the struggle for racial justice nudged the Supreme Court to recognize litigation itself as a form of political expression warranting protection under the First Amendment. Key case, NAACP versus Button. If you read NAACP versus Button, the court, Justice Harlan writing for the court, speaks about breathing room. Breathing room. We not only do you need rights, but you need breathing room to insulate yourself. You need space in order to actually make use of the rights that you have. To insulate news organizations from the wrath of local officials who loathe publicity that puts segregation in a bad light, lawyers convinced the Supreme Court to transform the law of libel so that now, in order to recover, a public official or public figure must show not only that a media outlet was erroneous in its reporting, but also that the media outlet knew that it was erroneous or showed reckless disregard for the accuracy of its reporting. Key case, New York Times versus Sullivan. In the 20th century, few cases more important to the way in which, again, we just intuit, we intuit this now. Media outlets weren't always so protected. One more. To protect civil rights protesters against hostile officials, their representatives persuaded the Supreme Court and other tribunals to craft rules that inhibit the authoritarian squelching of massed dissent. This arises from cases like Edwards versus South Carolina, or Shuttlesworth versus City of Birmingham, or Adderley versus Florida. In these and other ways as well, the 50s and 60s, the era of the Second Reconstruction, witnessed a remarkable, mutually reinforcing emergence of both racially egalitarian reform and libertarian sentiment, practice, policy, and law. Now, let's jump forward 3 decades. Take a fast jump. Let's consider a court ruling announced on September 22nd, 1989. The name of the case is Doe versus the University of Michigan. The author of the ruling was a United States District Court Judge Avern Cohn. The case was initiated anonymously. The plaintiff wasn't actually John Doe. He initiated the case anonymously. He was a graduate student who complained about the university's policy on discrimination and discriminatory harassment of students in the university environment. That was the name of the code that this anonymous graduate student challenged. And his claim was that this code violated his First Amendment rights. He said that he was concerned, his ability to do research and to talk with his colleagues, he said, was chilled by the existence of this code. This fella was a person whose specialty was the study of whether or how biological differences mirrored or created differences in personality traits and mental abilities. That's what he studied. And he asserted that certain controversial theories, positing that there were biology-based differences between races and genders, might be punishable under the university's new code. In his view, the new code swept within its scope not only speech that was unprotected by the federal Constitution's First Amendment, but also speech that was protected. And he asked the court, therefore, to invalidate the university's policy. Now, what precipitated the promulgation of the policy in the first place? There were several things. There were a bunch of incidents at the university in 1987. Let me mention a couple of them, just so that we all know what we're talking about. In one incident, an unknown person distributed a flyer on campus declaring, quote, open season, end quote, on, quote, saucer lips, porch monkeys, and jigaboos. Namely, he was referring, of course, to African Americans. Open season on jigaboos. That was the flyer that was distributed, and of course, it caused a furor. A few weeks later, on a campus radio station, a guest on the radio station delivered what was widely perceived as a number of racist jokes. And again, there was a lot of upsetment, and this led to a rally on campus, which led to the third big incident, because while there was this big rally on campus, a student hung out of a dormitory window a uniform, or maybe it was just a facsimile of a uniform, of a Ku Klux Klansman. And of course, the proverbial fuse was really lit then. The university president expressed outrage and reaffirmed his commitment to maintaining an open, welcoming, diverse campus. But some on the campus were dissatisfied with that response and demanded a more forceful response. And they were seconded. The folks on campus who said, we want more than that. It's not enough for the university president to condemn what was done. It's not enough for the university president to say, we have a welcoming campus, we want a welcoming campus. No, we want action taken against the people who were speaking in this way. And they got in touch with their representatives in the Michigan legislature. And some strategically placed legislators made it quite clear that they were interested in this matter and they wanted more done. There was one who said, quote, "Holding up funds as a club may be part of our response." A few months later, the university president resigned. His successor pushed for the drafting, promulgation, and implementation of the policy that was challenged in the lawsuit. Now, the policy that was promulgated declared, among other things, that in places such as classroom buildings, libraries, research laboratories, and recreation and study centers, persons were subject to discipline for any behavior, verbal or physical, that stigmatizes or victimizes an individual on the basis of race, ethnicity, religion, sex, sexual orientation, creed, national origin, ancestry, marital status, handicap, or Vietnam-era veteran status, and that involves an express or implied threat to an individual's academic efforts, has the purpose or reasonably foreseeable effect of interfering with an individual's academic efforts, or creates an intimidating, hostile, or demeaning environment. In assessing the constitutionality of this code, Judge Cohn consulted a body of case law that had, since the 1960s, consistently enhanced constitutional protections on campus. Now, a few minutes ago, I told you about the cases that began this case law, that first gave some sort of constitutional protection to students. Well, subsequently, there were further cases. And Judge Cohen, in this Michigan case, made reference to some of those cases. Let me mention two of them to you. In 1972, in a case called James versus Healy, the Supreme Court held that it would be unconstitutional for a public college to deny recognition to a local chapter of the Students for a Democratic Society, SDS, simply because of opposition to SDS's political aims. In this case, the Supreme Court expressly extended its Tinker decision to institutions of higher education, declaring that state colleges and universities are not enclaves immune from the sweep of the First Amendment. Indeed, according to the court, the college classroom with its surrounding environs is peculiarly the marketplace of ideas. The vigilant protection of constitutional freedoms, the court insisted, is nowhere more vital than in collegiate communities. The justices evinced sympathy for the defendant college president. They found that the president's abhorrence of certain features of SDS disruptiveness was completely understandable. But the court, and it was Justice Lewis F. Powell who was writing for the court concluded that the college president's mere disagreement with SDS's philosophy afforded no reason compatible with the First Amendment to deny recognition to that local chapter of SDS. The court said that the freedom of speech, press, petition, and assembly guaranteed by the First Amendment must be accorded to the ideas we hate, or sooner or later they will be denied to the ideas we cherish. In other words, it basically set forth what you might think of as sort of a do unto others, golden rule notion in constitutional law. Soon after Healy, the court adjudicated a case called Papish versus University of Missouri. That case involved a graduate student in journalism who was expelled for distributing a newspaper, the Free Press Underground, that reproduced on its cover a cartoon depicting policemen raping the Statue of Liberty and the Goddess of Justice. That same issue of the newspaper contained inside an article entitled, and here I'm going to go to euphemism, MF's Acquitted, which described the trial and acquittal of a youngster who had been a member of an organization known as Up Against the Wall, MF. The journalism student was charged with having violated a standard that prohibited, quote, decent conduct or speech at the university. A district court upheld the expulsion. So too did the United States Court of Appeals, which stated that on a university campus, freedom of expression could properly be, quote, subordinated to other interests, such as, for example, the conventions of decency and the use and display of languages and pictures. The Supreme Court reversed, declaring that the mere dissemination of ideas, no matter how offensive to good taste, on a state university campus may not be shut off in the name alone of decency. Now, getting back to Doe versus the University of Michigan, Judge Cohn did not simply examine case law, he also examined the record of the dispute before him, including the record of how the University of Michigan had implemented its code. And what he found was that there were a bunch of incidents in which students had been investigated for statements that they made in class. And he said, serious statements, whatever you wanted to think, you might disagree with the statements, but these were students in class making a statement. And he said, under these circumstances, no, we have to strike down this code. This clearly, this arrangement, this circumstance clearly, reasonably gives people pause. Am I going to get in trouble if I say this? I say, in a classroom? Your cafeteria? How, we can't have it. He struck it down. Since his ruling, scores of judges have followed suit. Now, the fact of the matter is, there are now scores of cases in which policies like the University of Michigan's policy have been challenged in court. And as things stand right now, all of them have been invalidated. All of them. Now, thus far, I've mainly been speaking in a descriptive voice. Thus far. I haven't sort of laid my own cards on the table. But now I'm at Act 3 in this talk, and in Act 3 I'm going to let my cards out on the table. So the question is, what do we make of this? I've tried in a fairly brief span to give you a sense of where the law is on this. So, okay, what do we make of it? A couple of things. Number one, in my view, the trajectory of the law has been in a good direction. Now, frankly, I'm happy to say that because, there's lots of areas in the law where I don't think that. The law's going in a bad direction. But this is one area where it seems to me that the courts, particularly the federal courts, have actually really distinguished themselves. I think that some of the finer moments in our courts are the moments in which the courts have stepped up and have protected freedom of expression, telling us things like this. Quote, from an old case, some of you will recognize the case, but this statement is one that is repeated when courts are called upon to adjudicate conflicts about freedom of expression on campus. You will often see the following statement, quote, "If there is any star fixed in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith." In the introduction, the comment was made, we're talking about something that's, very current, headlines. Well, all of you in your newspaper reading hear about things going on at various colleges and indeed, various sorts of educational institutions with respect to, for instance, taking a knee at a football game during or prior to the national anthem, Star Spangled Banner, all of the panoply of expressions of patriotism. A lot of controversy about that. A lot of controversy about that. Should that be allowed? Should it not be allowed? If there is any star fixed in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics. Let me go to another one. One comes across in these cases all the time. Quote, "It is firmly settled that under our Constitution, the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers." I think the law has traveled in a good direction in this context. Point two, it's not enough to have the law on your side. Not enough to have the law on your side. One thing that we should know, the law is under-enforced. I don't care what kind of law you're talking about, if it's anti-discrimination law, if it's, the law that prohibits, littering. I don't care what kind of law you're talking about. The law is always going to be under-enforced. Why? Because, to bring a lawsuit, that's difficult. It takes money. The law works slowly. All sorts of things can happen, even if you have a good case. There might be some sort of procedural snafu. It's not enough just to have the law on your side. It's good to have the law on your side. Very good to have the law on your side. But we all know that there is a difference between the law on the books and the law on the street. We all know that. Therefore, it's not enough simply to have legal doctrine on your side. As important, and sometimes, frankly, even more important than having the legal doctrine on your side, is having public opinion on your side. Having the habits of attentiveness to this issue firmly embedded in the minds of officials at schools. So it's not enough just to have the law on your side. You need public opinion on your side. Third point, there is no necessary conflict between champions of freedom of expression and champions of racial justice. Now, I really want to emphasize this point. In Doe versus University of Michigan, the first sentence in Judge Cohn's opinion was this, quote, "It is an unfortunate fact of our constitutional system that the ideals of freedom and equality are often in conflict." Now, from what I've just said, I actually applaud Judge Cohn's opinion. I think, however, that statement is incorrect. I don't think it's true that it is an unfortunate fact of our constitutional system that the ideals of freedom and equality are often in conflict. In fact, it seems to me that our history shows just the opposite. The camps of freedom of expression and the camps of racial equality, the champions of those two ideals, have historically marched hand in hand in our country. And that's a good thing. One of the reasons why I think that Judge Cohn might have said what he said is because since the late 1980s, there has arisen, particularly in academia, and here I have to say, particularly from the law schools, an idea that goes something like this. The idea is that words matter, that words can wound, and that if the legal system does not protect people who feel wounded, the legal system is disrespecting those people, particularly if those people are people from historically oppressed groups. And that idea has been set forth. It's been set forth by any number of legal academics. I think immediately of Mari Matsuda. Professor Mari Matsuda is one. I think of Professor Charles Lawrence. And there are others. And this is, or I think of, with respect to gender, I guess I think of Professor Catherine McKinnon. Ideas out there, and I think it was in reaction to that idea that Judge Cohen made his statement. Now, like I said, I disagree with his position, and I disagree because I think, like I said, the champions of racial justice and the champions of freedom of expression have historically marched hand in hand. That's part of my disagreement. There's another disagreement I have, though, and that is a disagreement with those who make the argument that a keen attentiveness, a keen commitment, a wholehearted commitment to racial justice requires a change, rather deep-seated change in our view of the First Amendment. I don't, in our view that ideas, even racist ideas, need protection. The claim is, no, they don't need protection. They ought not be protected. They are wounding. They are hurtful. Let's smash them. And so I want to challenge that notion for a bit. One ground on which I want to challenge that notion has to do with the claim that we are witnessing an upsurge in racist hate speech on campuses. If you read the literature, there's the language of upsurge, there's the language of epidemic. I'm doubtful about the factual predicate that undergirds calls for speech codes on campus or other mechanisms of policing. Maybe there's an upsurge. That could be. That's possible. But I'm skeptical. Oftentimes when I see the word upsurge or epidemic, I'm looking for a baseline. I mean, if there's an upsurge, well, there's an upsurge from something. Well, I want to know, well, when were things so much better? Is it really the case that one encounters more racist hate speech on campuses today than at some point in the past? I don't, maybe. But I read the materials pretty carefully. In order to make that argument, you have to have a baseline. And I haven't seen such a baseline established. I hear the assertion that things are worse, but I'm skeptical of that. I'm skeptical for another reason as well. It's often said that we need new policing mechanisms because, after all, we have these bitter conflicts on campus. We have this friction. We have these conflicts. Therefore, we need policing mechanisms to tampen them down. Well, is even bitter conflict attended by nasty, vicious, vile, racist language necessarily a sign of deterioration? I want to challenge that. In 1950, there was very little racial conflict at the University of South Carolina. There was very little racial conflict at the University of Mississippi. There was very little racial conflict at the University of Michigan, or at practically any other public institution. You know why? To have friction, to have conflict, you need the presence of people from, various groups. Well, on a racially homogeneous, all-white campus, no, you didn't have friction. You didn't have conflict. Now we do. Thank goodness. That's right. Now we do. Now, on many of our leading public campuses, most, probably all, there are an appreciable number of students who are racial minorities, for there to be groups, for you to have friction, for you to have conflict. Well, as far as I'm concerned, given the history of our country, far from that being a sign of retrogression, far from that being some sort of baleful thing, that is progress. Does it mean that we don't have work to do with these various conflicts, with these frictions? We have work to do. But let's keep things in perspective. I think another reason I'm concerned about this is the inculcation of habits. Everything is habit forming. Everything you do is habit forming. If there's a problem, and you're on a campus, and a group of students do something that you don't like. But that's putting it to, do something that you think is actually terrible. Do something that you think is racist or sexist or homophobic. Let's suppose that's the case. And by the way, let's suppose that you're right. Let's just stipulate that. Let's stipulate that you are correct in your perception of what other students have done. Question, what do you do about it? What do you do about it? Now, you could get in the habit of calling upon state authorities to discipline your fellow student. You could get in that habit. You could do that. You could get in the habit of saying, I can't handle this. You could get in the habit of saying, I'm traumatized. You could get in the habit of essentially empowering Big Mama and Big Daddy to take care of things. Remember what I said a few moments ago about in loco parentis? You could get in those habits. It seems to me that all of those habits are habits that are disempowering, that are actually, in the long term, destructive to the interests of the people who actually are upset. What about getting in the habit of turning to your own powers? For instance, your own powers of speech. They've said this. I'm appealing to public opinion. They've said this. I think it's wrong for this, and this reason. I'm appealing to all of you observing to come to my side. Seems to me that's a good habit. That's a good habit. Get in the habit of trying to persuade people. It's not an easy thing to do. You don't just up and be persuasive just because you think something. It takes practice. You have to learn how to be persuasive. Well, let's learn how to be persuasive. That's a very important thing to do, and it only comes through practice. It only comes through dint of habit. You have to learn not to be traumatized. I don't think it's the case, frankly, that you just are traumatized. We've all seen, we all are subject to, we're all subject to various cues. We learn whether we should feel traumatized or not. If you indicate to people that you should feel traumatized, yes, I understand that you are traumatized. Well, I mean, if you sort of create an environment where that is to be expected, well, I mean, you incentivize it, for goodness sakes. I don't think that's a good thing to incentivize. In our world, as tough as our world is, on my campus last year, this came up. This came up. There were students who talked about, I mean, you all read the papers, terrible things happen. There were students who were talking about, I feel traumatized. I said, I understand terrible things are happening, but actually, I want you to understand, you're talking about you were traumatized by something you read in the paper yesterday. Have you read the paper today? Do you think that tomorrow you're going to read the paper and not read about a tragedy? Do you think that as I'm speaking right now, there's not a tragedy occurring somewhere in our world? Right now, as we're here, somewhere in our world, unspeakable things are happening. Now, are you going to be traumatized every day? Because, I mean, if you're saying that you read about something that was unspeakable that happened and therefore you're traumatized, you are condemning yourself to a lifelong trauma. Because every day there is something unspeakable happening. The question is, how do you arm yourself? How do you create a person who is able to get out in the world and helpfully make things a little bit better? I don't think that you do that by, in a sense, wallowing in the sentiments, in the language of trauma. You want to change the world? Great. the world is a very difficult place to change. And you have to be tough. You have to be tough-minded. You have to be willing to confront all sorts of things in order to make things a bit better. And you are not going to become that person unless you develop a sense of habit, unless you develop habits of the sort that are actually facilitated by our First Amendment. Habits of, autonomy, habits of patience, habits of listening to people who are saying things that you hate, and yet then appealing to public opinion. Those sorts of habits, it seems to me, are the habits that actually will encourage the sort of characters that are capable of changing our world for the better. Now, final point. In the title, I talked about politics, and there is a politics going on here. There's a politics going on here. It's often said that the students that I've been, students that I've just been referring to, it's often said that these students are crybaby-ish, and sometimes they are. Sometimes they are. But I want to be realistic about it. Some of the critics of these students are crybaby-ish too. For instance, professors. I've come in contact with professors, who have, they're eminent figures, have tenure, have endowed chairs, and they are crying about some students who are complaining about them. Can you believe, this student said that I am racially insensitive, and that's political correctness. Well, hold it. All this student has done is use the student's rights to express what the student believes. What's the problem? The student hasn't prevented you from answering. Where do you get what? So you want to shut up the student? No. Students have a right to say what they believe. You have a right to respond. Sometimes the attack on so-called political correctness is, in my view, a disguised attack on liberalism. Let's take one media outlet, the Wall Street Journal. I've been following the Wall Street Journal's editorial page for a while. Now, I'm going to set forth a hypothetical. Let's imagine a public university that would invite, as its commencement speaker, let's say, just to choose a name out of the hat, Rudy Giuliani. And let's imagine that Rudy Giuliani was invited, and then there was an uproar about it, and then he was disinvited. I have no doubt that there are a number of media outlets, including the Wall Street Journal, that would say, political correctness run amok, isn't it terrible? This shows censorship, this shows repression, this shows the closed-mindedness of the students and their keepers at these universities. They've just gone nuts. Hypothetical 2. University invites as a commencement speaker Colin Kaepernick. And then there's a hubbub about it, and, a controversy, and then he's disinvited. My hypothesis is that there'd be a number of news media outlets who would not talk about political correctness there, but who would say, well, this is a, good sense has prevailed. A decent sense of patriotism has prevailed. Isn't this good? Now, there's politics all around this. I think we need to be realistic about that. And we need to be attentive to that. Underneath the politics, though, underneath the jockeying, is something more fundamental. And that thing that is more fundamental is our commitment as a society to openness, to debate, to persuasion, to a deep-seated, reflexive resistance to the imposition of orthodoxy. These are aspects of American society that I think all Americans, conservatives, liberals, radicals, socialists, anarchists, all Americans, I think we should all be proud of those aspects of our political culture, and that we should all do all that we can do to protect and nurture those features of our political culture. And there is nowhere that it is more important to do that than on our college and university campuses. Thank you very much.
Sorry about that. I'm actually just, my foot went to sleep. Sorry about that. So we're going to open it up to, yeah, I'm all right. So we're going to open it up to your questions, but before we do, I wanted to ask you a quick question, Randy, thank you, which is, when you were talking about the Alabama State College demonstrations that led to the students, is that the same one that's referred to in the Their Rising Voices advertisement? There was the New York Times?
No,
versus Sullivan?
No. Their Rising, that's a couple of years later.
Okay.
It's a couple of years later.
Okay.
Yeah.
So, all right, so now we know that. All right, so now we're going to open it up to you. And we have two people with microphones, Ronald and Casey. And we would ask that you wait until the microphone reaches you so that we can record your comments. And let me just ask that in the interest of time and to give as many people as possible a chance to ask questions, that you keep your questions short and to the point. So please raise your hand, and Ronald and Casey will come to you.
Good evening, my name is Alex, I'm a 3L. My question for you is, while you are at an institution of higher education and speaking specifically on the topic of free speech, why would you self-censor within the facts of a case when trying to explain part of your point?
Okay. Yeah. So, for instance, when I made reference in MF, is that what you're...
Yes.
Yeah. I think that there's a place for euphemism. I think we have euphemisms for a reason. And sometimes, it seems to me, it's perfectly fine to use a euphemism. Now, this really touches me deeply. I mean, I wrote a book titled Nigger, The Strange Career of a Troublesome Word. And as you can well imagine, I had to, talk a bunch about just even using the word. I was on a radio show once, and on this radio show, right before I went on the radio show, the manager of the station informed me that they had a very strict policy of never using the N-word full out. And they hadn't told me that, and I thought, oh, should I go on the show or not? And I decided to go on the show, and I played by their rules. And it was a perfectly good interview, perfectly fine. And I thought about it, and this issue came up. And the fact of the matter is that people have different sensibilities. People have, I don't think it's a bad thing to be attentive to the sensibilities of an audience. That's very different than saying, so for instance, I would not object to somebody engaging in euphemism. I would object if authorities, let's suppose I did not use euphemism. Let's suppose I did not, I spoke out what MF means. I think it would be wrong, to put me in jail. I think it would be wrong to expel me. But do I think it would be wrong in deference to the sensibilities of others, maybe not to vocalize the words entirely? No, I don't think that's wrong. And so I have friends, for instance, who've told me, I don't like to hear the N-word. Good friends of mine, smart people, very intelligent people, I thoroughly respect them. Don't use it. I don't think there's anything wrong with that. There's a reason why there is euphemism, and that too, the use of euphemism, I'm using my freedom of expression. Can I just,
Yeah.
What's your reaction to that?
My only reaction to that is that you spoke for some length about the idea of traumatization being a
Wait for a microphone, please.
Okay.
My reaction to that is that as you spoke for some length about traumatization being almost a societal pressure that is taught by people, that this particular epithet being an actual fact of the case and a representation of that fact, that perhaps censoring it in and of itself is detrimental to the marketplace of ideas?
I think it's a nice point. So, for instance, a case that really brings home your point, of course, Cohen versus California, the fuck the draft case. A guy goes into a courthouse with a T-shirt on saying "fuck the draft," and he's told to either take it off or cover it up or face the consequences. He challenges that, goes to the Supreme Court. The very beginning of the argument, the Chief Justice then, Warren Burger, good Minnesota man,
Yes.
asked the lawyer representing Cohen not to vocalize what was on the shirt. And picking up on your point, of course, the first thing the lawyer did was vocalize it. Because if he had not vocalized it, it would be a sort of a signal that, oh gosh, this really is terrible, terrible, terrible. This is so taboo, you couldn't say it. So, he had a tactical reason for saying it. I understand that. At the same time, I still stand by my point that, at different times you say different things. It depends on audience. So, for instance, let's suppose that you are in an audience where there are a bunch of, does it matter if it's an audience full of adults versus an audience that has a bunch of adults in it, but then you've got some fifth graders in it? Well, is it a bad thing to be attentive to, if I say this, maybe these fifth graders being like fifth graders are going to parrot it? So at least that's my thinking on this.
Hello, way up here.
Okay.
You've made the legal point that public universities, and I assume you're distinguishing private universities, of course, should not, and under the law cannot, impose discipline upon students or faculty for the speech that they use or the positions and ideas that they express. On the ethics side, you've talked about people ought to get over their self-traumatization and be a little less sensitive. And yet at the same time, in the answers you gave to the previous question, you talked about the need to be attentive to the sensitivity of your audience, and presumably the entire student body or the faculty. How do you apply your principles to the concepts of trigger warnings and safe zones or safety rooms or whatever on campus?
Well, a couple things. First of all, I think it's really important to be really clear on what we mean. Because sometimes these ideas come forth. It's easy to parody something. So I was on a campus where last June, where the whole question, this issue had really exploded. And there was I was actually I was rather disparaging toward especially the safe areas notion. And a student came up to me afterwards and said, and defended it and said, listen, what's going on here? A lot depends on how things are implemented. Is there a place in a big, diverse university, is there a place for organizations, for places, for settings in which people who have a common issue or a common problem or a common difficulty or a problem enemy or a common experience to get together and exchange ideas, exchange, experiences before sort of going out in the world and confronting the world. And this person said that, that's all we're up to. We're simply up to getting together in our little, aren't there lots of clubs where people get together, talk among themselves? Isn't that what families do very often? They get around, a table. They have a certain level of comfort. They have a certain level of intimacy. They have a certain level of confidentiality. This person was suggesting that that is what was up. Anything, and this person was saying, we're not damning other people. We're not telling other people that they shouldn't say what they want to say. All we're asking for is the facilitation of an area in which we can get together and in a sort of close-knit way try to nurture one another, teach one another, learn from one another. I didn't see anything objectionable about that. As for trigger warnings, would I have an objection if my dean called me and said, Kennedy, I'm looking at the dean of the law school here. I would have an objection if the dean of the law school called me and said, Kennedy, before you teach, you've got to do this, that, and the other. Yeah, my back would be up about that. My back would be up about that. On the other hand, if I was dealing with a subject that I thought was unusual, let's suppose that there was some unusually graphic document. It had a picture in it that was just unusually gory, something that just really would just jump out. Would it be a bad thing if I said, hey, listen, I want you to know, first of all, I'm putting a cover over the document so that when you get it, you're not going to just see it full force. I want you to know that if you turn this over, you have to be prepared for what you're going to see. Would that be such a bad thing? No, I wouldn't think that would be such a bad thing. That's a trigger warning in a way. I, frankly, don't do things like that very much, especially in a law school. I mean, I do, frankly, I tend to be a bit impatient with demands for, or even requests, frankly, for trigger warnings and such when people are at the stage of law school. Now, you know, I think maybe my reaction would be probably a bit different if we were talking about junior high school. It might be different even in high school. College, I think we're really dealing with young adults. Law school, for goodness sakes. I mean, in law school, if you're a first-year law student, you're within 9 months of having people's, property and life in your hands. I mean, if you're a first-year associate, you're actually acting as a lawyer. And so I get rather impatient at that point. But I think educators do have a difficult role when they're dealing with students of varying ages, coming from various places, having a wide range of expectations. I do sometimes think that the newspaper coverage of these issues flattens out the issues. And it's, makes a parody of some of the things that educators are saying. Educators have a difficult job. And I think that just like I talked a moment ago about the virtues of patience, the virtues of persuasion, listening to people. I think, educators need to be listened to as well. We need to give educators a break. Sometimes you make a decision and you do something, and upon reconsideration, it wasn't the optimal thing to do. Okay. Don't damn people for that, for goodness sakes. People are trying to do the best they can do, and sometimes they make mistakes, in the crucible of the action. So with respect to trigger warnings, with respect to all of these things, they have their problems, do understand what has given rise to them, and then let's all, work, talk, to try to move things forward.
All right, so my name is Brittany, and I'm an undergrad here, and first, it is related to the last question, but I'm going to make it known that I am an advocate for trigger warnings in classrooms, just so you understand where I'm coming from. Mm-hmm. I did respect your answer of how you can recognize when something is like unusually graphic or gory, but that's not necessarily what a trigger warning is. It is telling your audience that something coming up could incite a physical response, an anxiety attack, a panic episode. It's usually something for victims of sexual violence, like rape, or abuse, or people who have received like really traumatic injuries in war. Those are the pretty standard ones that I think we've all heard of. So my question is, and you did talk about like the dean coming to you and asking about trigger warnings, or you finding something unusually gory. But what about if a student came to you and said, hey, could you please let me know when something in your classroom is involving X, Y, Z? What is your thought on that? Because I get your response on someone from above telling you, but what about a student in your classroom?
Mm-hmm. Okay, I teach at a law school. Now I'm trying to think if a student said this to me. I would listen. To be perfectly frank with you, I think I would say, listen. It'll be very difficult for me to accommodate your request. Because, I mean, I don't teach criminal law anymore, but let's suppose I'm teaching criminal law. I guess, I mean, you know, I guess I could just tell you every day, every class, trigger. I mean, you know, every criminal case is a tragedy. Every one. There is not, in a criminal law class, every year that I taught criminal law, I taught it for 5 years, every year there was at least one time in the course where somebody ran out of class crying because there had been, we were dealing with a case that that triggered a response. The last I remember was a case we were talking about, doctrine of manslaughter. And this was a student who had a sibling who had recently died in a case of drunken driving. Now, everybody has been affected one way or another by crime. Either somebody's been victimized by crime, or somebody has a relative who's been falsely accused of crime. Under those circumstances, what does one say? It seems to me that, you're in school, that's what's coming down the pike. It doesn't have to be, if I was teaching a literature class, teaching a class on world literature, I mean, and let's talk about gender dynamics. I mean, world literature, rape, come over and over. Rape, seduction, other, bad actions, all over the place. What is one to do? It seems to me that at a certain level, like I said, if we're talking about college, if we're talking about graduate school, if we're talking about professional school, my sense is that a college student should know the facts of life, know that life has tragedy in it, has delight in it, has crime in it, has all sorts of things in it, and should be prepared for that. If I'm teaching a course on, modern world history, and you're getting ready to discuss the Second World War, what does one do? Every class, trigger. You are going to confront the most grotesque things. So it seems to me that college students ought to know that. And I don't feel, frankly, that I'm perfectly willing to say this. And I'm perfectly happy to say it one time. I guess I'm going to be unwilling, however, before every class to go through that, because it seems to me that there's a way in which people should just know that. You think I'm wrong on that?
I don't think you're wrong. I think this is something we might just have to agree to disagree on, but I think that when people talk
Well,
about...
you think I'm wrong then?
I guess. When I hear, and I have a lot of my own professors in this classroom, one that is my professor right now and one that was my professor last year. When I hear professors talk about trigger warnings, I get really angry because they don't really understand what it is. It's not, hey, World War II sucked. It's, hey, we're watching a movie today where there's a rape scene, and if you're a victim of rape, you don't have to watch it. It's not, the world is tough, get over it. It's, you experienced a trauma that the majority of humans will never have to face, and you should not have to go through it again. It's letting someone that is a victim, not a sister of a victim, not a friend of a victim of a trauma that the majority of these people in the room will never face. It's letting them know that it's coming up, and it's their choice whether or not they have to sit through that, because it could incite something that causes them physical harm. That's the movement behind trigger warnings. It's not, accepting the world sucks or like getting over it type thing, and that's what I hear a lot coming from my own professors.
Yeah.
And I want to change that dialogue, and granted, I'll take on that burden. But that's what I hear from a lot of professors and faculty and students, is just people need to get over it. And like, you can't say that to someone that experienced something as violent and awful as rape if you have never been in that situation, because you have no idea what it's like. So when I ask certain professors for them to tell me if something pertaining to XYZ is coming up and they refuse, I will drop their class. Mm-hmm. And a lot of people will think that I am just awful, 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 or a baby or a crybaby and I need to get over it, but I'm not going to subject myself to that same trauma that makes me incapable of breathing ever again.
Okay.
Like, and I get what you're saying and I agree with it on some point, and then I care more about the victim, I guess.
I guess I have two responses to that. One, a practical response, which is, the way you tell it, it's altogether clear what is going to happen in class that may be inciting or provoking of an emotional reaction. Well, I teach lots of classes, and to tell you the truth, there's a lot that happens in class. Some of the best classes, by the way, are classes. It's very surprising what's come up. I mean, in my classes, I'm constantly, sort of posing hypotheticals. Some I've thought about, some I haven't thought about at all. Or some student comes up with a hypothetical, or the conversation takes a turn here or turn there. And the fact of the matter is, a lot of teachers, certainly I've thought about class a lot. I've imagined how it might turn out, but there is a lot of surprise that happens. Now, if something comes up that I hadn't anticipated, what? Am I negligent because I didn't anticipate it? Things are going to come up. That's one objection I have. Second, I guess I do challenge. I hear this said, people say, well, this is my experience, this is the way I am, you be your way, I'm going to be my way. Well, I'm not going to, I understand your way, but I don't have to accede to your way. I don't have to, if you say that you have an emotional reaction to such and such, I can understand your reaction. I can understand where it comes from. I don't think I'm a bad person if I say to you, I don't think that's a good way to be. You might disagree with me. You're welcome to disagree. But I do not think it's a bad thing for me to say you're leading with your chin, and gosh, you are really going to have it bad given just how hurly-burly a world we live in. If you're leading with your chin, because there are going to be lots of circumstances that come down the road in which, you're not going to be able to approach people the way that you're able to approach your professors. And, wouldn't it be better to work on various things such that something comes up, you're not hyperventilating. I mean, hyperventilating because something comes up, it seems to me that's not a good thing. And I don't think it's a bad thing for me to say that you should work on strengthening yourself so that you can go out in the world and be a person who changes the world so that fewer bad things happen in the world. But maybe maybe we do disagree, but in any event, that's how I view it.
Okay, I think we have time for one more question.
Well, I don't want to be the last question, but thank you for being here. My name is Suzanne. I'm a policy student at the Humphrey School. I am going to also speak on the trauma-related piece. So, yes, I do. I am also in the belief that some people do deal with trauma, and we do need some trigger warnings. However, I think I also agree with you in that if you're going to be in a profession like being a lawyer, you need to be able to deal with those emotions that you have as well. However, I don't think the way of just shutting trauma off is healthy for a personal well-being. So let me see. I guess I'm kind of asking, what are the resources at a law school that can help students deal with that and then utilize that trauma and those stories? Because from a policy standpoint, having those personal stories is kind of a way to garner public opinion and get people to listen. So yeah, what are the resources that are available to you?
Yeah, I can answer. I can only answer in a fairly general way. It's at my place, in my law school, a lot of emphasis is placed on telling students that along with personnel that can attend to the flu and other stuff like that, a broken wrist or whatever. We also have psychological services. I mean, again, the world's a very tough place. We all know that people do suffer from anxiety. People do suffer from depression. There is no shame in that. We're very strong attempt. Let's destigmatize that. That's right. We all, and everybody has something. So I'm not, again, just to answer you directly, the psychological services. And above psychological services, though, again, this question of trauma, I think that there are different points of view that people have. It may very well be that, in fact, I'm certain, it's not may very well be, I am certain that we have not gotten to the bottom of this. This is an ongoing conversation. The question of how best to deal with this, I'm not saying that what I earlier suggested is the best way of dealing with this. I'm all ears. And I think everybody should be all ears, because I don't think, I don't know of a panacea for this. I do think that different theories, different points of view ought to get a hearing. There is a very venerable philosophical tradition that, at least in my experience, I'm finding to be a rather attractive tradition. I would like to know more about it. It's the tradition of Stoicism. It's the tradition of self-mastery. It's a tradition that shows up in lots of different cultural forms. And I find it attractive. The idea of, you can't control the world, but you can control yourself. Well, people have been arguing about Stoicism for eons. They will continue to argue about them. I think that we need to wrap our heads around these various traditions, various ways of going about things, learning from one another. And I think over time, if we learn from one another, over time, we will reach more considered, more informed positions. I know that's doesn't have a nice bow tie on it. It's a little bit, mushy. It's a little bit murky. But that's the best I can do. One last thing. One of the earlier questioners, I think it was the gentleman way back there, who said, now, of course, in your remarks, you were talking about public universities, which is true. I never said anything about private universities. And do I have a minute?
Yeah, you have a minute.
The private university poses some different issues. So, for instance, I think that there's some people who take the position that all the universities should be under the same sort of First Amendment type regime. I don't take that position. I think that all public universities should be under the First Amendment regime, robust, wide open, fine. On the other hand, one of the good things about our system is we have public universities, but they're private universities. And I think that a private university should have the breathing room to do its own thing. I'm for, and it sounds paradoxical, but so be it, I'm for giving breathing space to repressive campuses. So let's imagine that there is a group of people who come to the conclusion, you know what, there's too much cursing in the world. There's too much cursing. We're going to have a campus in which there is no cursing, no epithets, no this, no that. Now, I wouldn't teach there. I wouldn't go there. I wouldn't send my kid there. But should there be an opening for such universities? In my view, yes. Pluralism would demand that. Just like we have religious universities that are able to privilege a religious tradition or even keep out other traditions. Seems to me fine. I think I'm for the secular version of that. So if you have a university, Capitalism University, only capitalists are welcome here. As far as I'm concerned, fine. It has a lot of downsides, but the question is, should it be permitted? My view, yes. Any event, and this will be the last thing, truly.
I believe you.
I've had a really fun day here, and I have, again, it's absolute privilege to be a paid student. And as an academic, that is exactly what I am. And it's actually events like this, really, that make being a member of an academic community such a great thing. Thank you very much.
Thank you. So thank you, Randy, very much. And I also want to thank you, our audience, for joining us tonight. As some of you know, copies of some of Professor Kennedy's books will be available in the atrium just outside the auditorium. He will participate in a book signing in just a few minutes. We have to take a couple of pictures, but then he'll be out there. So if you want to go out and see what is to be had, please do so. I encourage you to fill out one of the comment cards available inside what you think. Or mailing list, and we hope to see you in the future and that you will be back next year for the 32nd annual Silha lecture. Thank you. Thank you so much.